In Arizona's real estate landscape, the sale of newly constructed homes involves more than just delivering a finished structure. It carries with it a series of implied legal promises between the builder and the buyer. One of the most important of these is the builder's liability for habitability, often referred to as the implied warranty of workmanship and habitability. This principle has been shaped through decades of Arizona case law and serves as the cornerstone of consumer protection in new home construction. The doctrine of habitability was first established in Columbia Western Court v. Vela, 1979, where the Arizona Supreme Court held that a builder-vendor of a new home implicitly warrants that the construction was completed in a workmanlike manner and that the home is suitable for habitation. This warranty arises automatically by operation of law and does not need to be written into the purchase agreement. In simple terms, when a buyer purchases a newly built home, the builder is legally responsible for ensuring that the home was built correctly and is safe and livable. This principle was later reinforced in Richards v. Powercraft Homes, Inc., 1984, one of the most influential cases in Arizona real estate law. The Arizona Supreme Court extended the implied warranty protection not only to the original purchaser, but also to subsequent buyers, those who purchase the home later, even if they have no direct contract with the builder. The court reasoned that public policy favored protecting consumers against latent construction defects, issues that might not surface until years after the original sale, such as foundation cracks, plumbing leaks, or electrical faults. By extending liability beyond the first owner, the court recognized that the builder's duty of care extends to all foreseeable users of the home. To understand this rule in practice, consider a new home development in Scottsdale built by a licensed contractor. 2 years after the first owner sells the home to a new buyer, structural cracks appear in the foundation, revealing improper compaction of soil during construction. The second buyer contacts the builder, who refuses responsibility, claiming no contractual relationship exists. Under Richards v. Powercraft Homes, the second buyer can still bring a claim for breach of the implied warranty of workmanship and habitability. The court would likely hold the builder liable for the latent defect, even in the absence of privity of contract. Another case that further clarified the boundaries of builder liability is Nastri v. Wood Brothers Homes, Inc., 1988. Here, the Arizona Court of Appeals addressed whether a builder could disclaim or waive the implied warranty through contractual language. The court held that a general disclaimer clause in a purchase contract cannot override the implied warranty unless it is clear, specific, and negotiated, meaning that buyers must knowingly and voluntarily agree to waive these protections. The decision emphasized that Arizona's policy strongly favors consumers and disfavors attempts by builders to contractually escape responsibility for defective construction. The implied warranty covers both workmanship and habitability, two distinct but related concepts. Workmanship refers to the quality and skill used in the construction process, how the work was performed. Habitability refers to whether the home is safe, sanitary, and suitable for its intended purpose as a dwelling. A home might be structurally sound, yet fail the habitability standard if, for instance, it lacks safe electrical wiring or proper drainage that prevents mold growth. Builders in Arizona also have continuing obligations under the Arizona Registrar of Contractors, ROC, regulations. Under ARS, Paragraph 32, 1154, contractors can face disciplinary action for poor workmanship or failure to correct construction defects within a reasonable period. This regulatory framework works hand in hand with the judicially recognized implied warranty, ensuring that buyers have multiple avenues for recourse, both through civil litigation and administrative complaints. The implied warranty, however, is not indefinite. Arizona courts have recognized a statute of repose under ARS, paragraph 125552, which limits claims against builders to 8 years after substantial completion of the home, or 9 years if the defect is discovered in the 8th year. This ensures a balance between consumer protection and fairness to builders, preventing perpetual liability for long-standing structures. Example scenario. A couple purchases a new home in Queen Creek directly from a builder. 3 years later, roof leaks develop, revealing that improper flashing and low-quality materials were used during construction. The builder offers to patch the roof, but refuses to perform a full replacement. The homeowners file a claim for breach of the implied warranty of workmanship and habitability. The court finds in their favor, ruling that the roof's poor installation violated the builder's duty under Columbia Western Corpus vs. Vela and ARS. Pgrov 32-1154, requiring the builder to repair or replace the defective work and pay damages. Review summary. Arizona law imposes an implied warranty of workmanship and habitability on all builders of new homes. This warranty guarantees that the home is constructed with reasonable skill and is fit for habitation. Landmark cases like Richards v. Powercraft Homes, Inc. 1984, solidified the doctrine and extended its protections to subsequent buyers. Builders cannot easily disclaim these warranties, and liability may persist for up to 8 years after construction. Together with the Registrar of Contractors Enforcement Authority, these rules ensure that builders remain accountable for the quality and safety of their work. Discussion prompts. Why did Arizona courts decide to extend the implied warranty of habitability to subsequent buyers? Answer: because public policy favors protecting all homeowners from latent defects that could compromise safety or livability, even if they were not the original purchasers. What is the main distinction between workmanship and habitability? Answer: workmanship relates to how the home was built, while habitability pertains to whether the home is safe and suitable for living. Can a builder legally disclaim the implied warranty in a contract? Answer: only if the disclaimer is clear, specific, and voluntarily agreed to by the buyer, which is rare and heavily scrutinized by Arizona courts. Closing remarks. Builder liability for habitability represents the intersection of law, ethics, and consumer protection. Arizona's courts have consistently emphasized that home buyers deserve safe, properly constructed homes, and that builders, as professionals, must stand behind their work. This principle not only safeguards the public, but also enhances trust and accountability within Arizona's booming construction and real estate industries for licensees representing buyers or sellers of new construction. Understanding this body of case law is essential to ensuring clients are informed, protected, and empowered. Most buyers of new construction do not see the benefits of an outsider inspection company inspecting the property while it is being built to make sure that the home is built up to today's standards, and that the builder did not miss a step and completed the job in a skillful, structurally sound, and livable manner.